Welcome to this afternoon session on all things criteria, where there will be four of us talking about the criteria that some states apply when drawing districts. I have been asked to do some housekeeping. So we do want this to be an interactive experience for all of you. So I want to point out a couple of key features on this page. To the right of the screen where you can see me, you will note tabs that say chat and Q&A. The chat function is to allow you to interact with colleagues attending the session. If you want to ask our speakers a question at any time during this hour, please use the Q&A tab. And if you see a question that you'd like from someone that you would like to move up the queue, you have the opportunity to upvote that question using the up arrow. I'll be posing some questions to the speakers towards the end of the hour. And if at any time you need technical help, please use the help button at the bottom right of the page. So I am Jerry Berry. I am my day job is an assistant director with the Office of Legislative Legal Services for the Colorado General Assembly. There I lead a team that drafts bills and amendments to bills in the areas of civil and criminal law, education, and public benefits. But I'm also the one in the office who handles issues dealing with redistricting. And given the subject area of my team, it may sound strange that I'm the one who handles redistricting, but it goes back to 2001. In 2001, I was asked to help staff the Colorado's Reapportionment Commission. And ever since then, the office has not let me get away from redistricting. That's not to say that I really have wanted to get away from redistricting. I think it's fascinating and it's a nice change to what I am usually doing. So if I started in 2001, you notice that this will be my third round of redistricting. And when I was preparing this speech, I was going to mention that I'm sure there were some people in the seminar who are on their fourth or fifth round of redistricting. And I was amazed to hear this morning or this afternoon that there was someone who is on his seventh round of redistricting. So hats off to that person. So the plan for this afternoon is I will start with a brief introduction. I'm going to touch on federal criteria. That's not the focus of this session, but I'll mention federal criteria. We will then separately talk about the traditional redistricting criteria, and then I'll come back and talk about some new criteria that may be emerging. So as you see, that's a long list of criteria. And your first question may be, where do I find the criteria for my state? It may be in your state constitution. It may be in state statutes. In some states, it's actually just resolutions of the General Assembly. And if you've had the unfortunate experience of having redistricting issues go before your courts, there may be court opinions where the court is relying usually on traditional redistricting criteria to set up the criteria for the state. The next question you may have is, why do we need criteria for drawing districts in the first place? First off, when you're looking at a blank page of your state, where do you start? Well, the criteria and sort of the priority that your state has for the criteria tells you where you should start. Is maintaining county boundaries most important? Are there issues about minority voting rights that you need to consider? That may be where you want to start drawing your plan. The criteria is also useful when you're comparing plans. Otherwise, you're just looking at lines on a map. How many times does this plan split a county? How many times does this plan split something else? What are you going to use to compare different plans that come before you? And finally, I think following that criteria avoids some extreme political gerrymandering. So hopefully you will avoid drawing some districts like these two. The district on the left comes from North Carolina, and the one on the right comes from Maryland. After I did that, I thought maybe I should have switched which one's on the left and which one's on the right. But these are actually two of the districts that were before the United States Supreme Court in the case of Rucho versus Common Cause. That's where the court held that political gerrymandering was non-justiciable in federal court. That is, federal courts won't hear claims that political gerrymandering are unconstitutional. And the court did that because it couldn't fashion a standard by which to judge how much political gerrymandering is unconstitutional. Where do you draw that line? So when we go through some of these criteria, you may want to consider these two districts and how well maybe they comply with the criteria that we'll be discussing. As I mentioned, there are federal criteria that every state must follow. First, equal population among districts. For congressional districts, this means precise mathematical equality. Oftentimes, states will have a deviation between the most populous district and the least populous district of only 1 or 2 people. They're that close. In all other districts under the 14th Amendment, it only requires substantial equality, which gives you more room for a broader deviation than is required for the congressional one. Racial discrimination under the 14th Amendment, you can't intentionally discriminate against minorities. And along with that, you have to comply with the Federal Voting Rights Act. Now, there will be a later session in the seminar that deals with racial discrimination and the Voting Rights Act. So these are the federal criteria, and the focus of this session is really on state-specific criteria. So as I mentioned, it can be broken down between traditional redistricting criteria and some emerging criteria. The traditional criteria includes compactness, avoiding strange arms of one district stretching out into another. And there are actually mathematical formulas that can be used to measure compactness. Preservation of communities of interest. Now, this may be keeping neighborhoods in a city together, or it may be keeping economic interests such as agriculture together in one district. Contiguity, all parts of a district must be touching the other parts of the district. You can't have a island from one district in the middle of another district. Preserving political subdivisions. So except when necessary to equalize population, you shouldn't split counties or cities and towns. And I'm going to break away from the list for just a second here. Not only do you need to consider the criteria themselves, but you need to consider the priority in which you are to follow when you're following the criteria. So for splitting counties and cities, if in fact you need to do that to equalize the population, those federal requirements are above the state requirements of not splitting those. Another issue, even within that, is are you to preserve county boundaries or do you preserve city and town boundaries? In Colorado, at least, we have several cities that cross county boundaries are in more than one county. Indeed, in the city of Aurora, which is the second or third largest city in Colorado, that stretches across 3 different counties. Is your priority preserving those county boundaries, or is it preserving the city boundaries? Back to the criteria, preservation of the cores of prior districts. This is so that the people have some continuity. They know what district they reside in. They may know their representative and know how to get in touch with that representative. Avoiding pitting incumbents against one another. And I think this is so that an incumbent is not ousted because of redistricting. The voters are the ones who really ought to be deciding if a representative is ousted. So that's sort of a list of the traditional redistricting criteria. More recently, some additional criteria have emerged. First, well, I think it's important to note that when you go through these, you may find that they conflict with some of the traditional redistricting criteria. First is prohibitions on favoring incumbents, candidates, or parties. This obviously conflicts with protecting incumbents and not pitting incumbents one another. It encourages new people getting involved in politics. Another one is prohibiting the use of political data in political and election data in drawing districts. And this is really aimed to minimize the political gerrymandering so that, and that is political gerrymandering. So you draw districts so the candidates of your party have the best chance of winning the most number of districts. And the final new emerging criteria is a requirement that you create as many competitive districts as possible. And the thought here is that representatives should be chosen at the general election, not in the primary. So it should be a competitive district. So with that sort of introduction and summary, I'm going to turn it over to the other panelists for a more in-depth discussion of each of these criteria. So Michael, take it away.
Thanks, Jerry. I appreciate it. And it's been great, working with you on this panel. I have to say that one of the great things about NCSL, at least from my perspective as nonpartisan staff, is that you get to have contact with people who do similar work in other states. And I'm an attorney. There just frankly aren't that many attorneys. It's a small fraction of attorneys, in the United States that are legislative drafting attorneys. So it's really good to be able to meet people like Jerry and others. Yeah, so I'm Mike Gallagher. I'm a legislative drafting attorney with the Wisconsin Legislative Reference Bureau. I draft in a number of subject areas that include state government and finance, public records, open meetings, and other areas, and of course, elections, which I have a sneaking suspicion is going to be a rather busy drafting area this session. With respect to redistricting, and I should say also that Joe and Stacy and I, we pretty much work as a team at LRB, dealing with all things related to elections. With respect to redistricting, most of what we've done so far is to train local governments on the law and process related to redrawing local district boundaries. So now we're turning our attention to state legislative and congressional redistricting. In Wisconsin, redistricting bills are passed just like any other law, go through the legislature, subject to veto by the governor, and LRB actually drafts the bill. Well, actually, we have computer programming that converts maps into an actual bill. So the 2010 cycle was a notable exception, but most of the time in most recent decades, courts have ended up putting maps in place in Wisconsin. So the two traditional redistricting principles that I'm going to be speaking about are compactness and preservation of communities of interest. Compactness represents the principle that districts should be reasonably geographically contained. Another way of thinking of it is that the distance between all parts of a district, should be minimized to the extent possible, and we'll talk about that later. 40 states have a compactness requirement in their constitutions or statutes with respect to state legislative and congressional redistricting. So, for example, the New York Constitution. requires that the state's congressional and state legislative districts be as compact in form as practicable. I don't know why we always want to use that word in the statutes and constitution as opposed to possible, but anyways, it's harder to pronounce. So there's, this is very standard language, and there's a virtually identical compactness requirement in Wisconsin's constitution, but only for the state's state assembly districts, not for the state's state senate districts and congressional districts. But of course, that doesn't mean that compactness isn't an important consideration for Wisconsin state senate and congressional districts, or as well as for all other districts in states where there isn't necessarily an explicit compactness requirement for state legislative and congressional districts. And that's because the courts look at compactness when scrutinizing any redistricting plan. As the US Supreme Court said in Shaw v. Reno in 1993, districts with, quote, dramatically irregular shapes may have sufficient probative force to call for an explanation, end quote. In Shaw v. Reno, the Supreme Court was asked to evaluate 2 majority African-American congressional districts. I should go to that next slide. Majority African-American congressional districts in North Carolina. The more unusually shaped of the 2 was the 12th congressional district. And I don't know how well you can see it from your perspective, but it's the light purple district that is in the center of the state. And you can see that it completely bisects, or appears to at least, that light green district. So that's the district we're talking about. The Supreme Court described it in a bit of a colorful way. They said, quote, it is approximately 160 miles long and for much of its length, no wider than the I-85 corridor. It winds in snake-like fashion through tobacco country, financial centers, and manufacturing areas until it gobbles in enough enclaves of Black neighborhoods. One state legislator has remarked that if you drove down the interstate with both corridors open, you'd kill most of the people in the district. So that's a little bit dramatic, but you get the point, right? It's an oddly shaped district, to say the least. The Supreme Court ultimately held in 1996 that the district was in fact an unconstitutional racial gerrymander. And it sounds like you're training on the Voting Rights Act and perhaps racial gerrymandering is coming after this presentation at some point in the in the program, but at least you'll be a little bit familiar with some of the terms. So what the court found was that that race was the predominant motivating factor in drawing the district's boundaries, and that the Voting Rights Act didn't justify drawing the district in the way that it was drawn. The court said that the district shape was, quote, highly irregular and geographically non-compact by any objective standard that can be conceived. So that brings us to an obvious question. What standard do we use to measure the compactness of any given district? Well, there isn't a single generally agreed upon standard, although there are mathematical formulas used, including ones that evaluate compactness based on how closely a district resembles a circle. But the Supreme Court uses a little bit less sophisticated test, let's say. They use the eyeball test. And, looking at this map, you can see, well, the eyeball test, it's a pretty good test. So if you look at this is of course the old congressional district map for North Carolina, you can see that you can easily pick out, with your eyes, the relatively compact districts and distinguish them, from districts that are much less compact. So like, for example, the dark green one in the center of the state looks pretty compact. And this large brown one is District 1, the darker brown one. So that was the other district that was at issue in Shaw v. Reno. And the court, I think the court described it as looking like a Rorschach inkblot test. Anyways, I don't think that district was ever overturned, only the 12th congressional district. So compactness is a redistricting criteria that applies to the physical geography covered by a redistricting plan. Respecting communities of interest, on the other hand, is a principle that takes into account the characteristics of the people themselves who reside in diverse areas throughout a state. In general, preserving communities of interest means attempting to group like-minded or similar people in a district so that they may elect representatives of their choice who reflect their common values in a manner relevant to legislative representation. So there are approximately 26 states that have constitutional or statutory requirements to at least consider communities of interest in state legislative or congressional redistricting. Incidentally, Wisconsin is not one of those, but in our statutes, there is a requirement that when local governments draw ward boundaries, which are called precincts in other states, that the local governments have to take into account the existing neighborhoods and communities of interest that exist at the local level. So some states require respecting communities of interest without elaborating at all on what that means. So for example, this is a good example. New York's Constitution requires simply that the state's Redistricting Commission consider the maintenance of communities of interest in drawing congressional and state legislative maps. Other states have a communities of interest requirement, but they don't actually use that, the magical words, communities of interest. So the Constitution in Alaska, for example, that provides a good example. It requires that districts for the state's House of Representatives be formed of territory containing as nearly as practicable, there's that word again, a relatively integrated socioeconomic area. Some states provide more elaboration, and California's Constitution provides quite a bit of it because it describes in detail what can constitute a community of interest. So, and it even provides many examples. Examples include urban, rural, industrial, and agricultural areas, as well as areas in which the people share similar living standards, use the same transportation facilities, have similar work opportunities, or have access to the same media of communication relevant to the election process. So that provision, pretty well sums up the kinds of interests that make up communities of interest for purposes of redistricting. So before I hand you off to Stacy, I just want to make a couple of other points. So first, it's important to note that the principle of communities of interest is distinct from federal requirements relating to the protection of racial and language minority groups in a redistricting plan. However, when communities of interest align with a specific population's race or ethnicity or ethnic characteristics, care must be taken to ensure that legitimate political considerations, and not race, predominate in drawing a district's boundaries. But there's a big caveat: unless it's necessary to do so in order to comply with the Voting Rights Act of 1965. If not, a court might find that the district is an unconstitutional racial gerrymander. And incidentally, in the in the litigation in Shaw v. Reno, the litigation over North Carolina's 12th congressional district, one of the defenses that was raised was that the district was drawn based on communities of interest, not based on race. And I think what the court ultimately said is that it didn't find that the legislature actually had information about communities of interest in front of it when it was drawing the district. So that's something that's important to keep in mind. All right. Second thing, so you can see that if you draw district boundaries to circumscribe communities of interest, the principle of compactness may have to give way, right? At least to some extent, and sometimes to a great extent. So these two principles, they are in tension with each other, but neither is absolute. There is no requirement that districts be perfectly compact. Consideration of other redistricting criteria, such as communities of interest, will often mean that a district is not nearly as compact as it could otherwise be. And so with that, I will turn it over to Stacy.
Thanks, Mike. Good afternoon, everyone. My name is Stacy Duros, and I am a legislative analyst at the Wisconsin Legislative Reference Bureau. Legislative analysts provide confidential, nonpartisan research to the Wisconsin legislature, as well as to state and local officials and agencies, as well as the public. Analysts also work closely with LRB drafting attorneys on different subject areas. So as Mike had mentioned, I work closely on elections-related research with Mike and with Joe, who you will be hearing from shortly, and he's covering two other traditional redistricting principles. Today, I'm going to cover the two most common traditional redistricting principles that are currently imposed by the states on congressional or legislative districts. The first principle that I'll be discussing is contiguity, and the second will be the preservation of political subdivisions. So with that, let's start with contiguity. Contiguity refers to the general principle that all areas within a district be physically adjacent. A district is considered to be contiguous if all parts of that district are in physical contact with some other part of the district. For example, if you take a look at the screen, the yellow district on the left-hand side is considered to be contiguous because you can travel from any point in that district without crossing the district's boundaries. In other words, all parts of the district are connected and attached to each other in a single unbroken shape. So imagine being able to trace the borders of the yellow district with a pencil. You should be able to do so with one unbroken line. In contrast, looking at the blue district on the right-hand side, it is not considered to be contiguous because you cannot travel from any point in that particular district without crossing the district's boundaries. In other words, some parts of that district are not connected to the other parts. Again, with the pencil idea, imagine being able to trace the blue district's borders with a pencil. And so you would at some point have to pick up that pencil to reach other parts of the district that are not connected to the district itself as a whole. Overall, contiguity appears to be pretty straightforward. And like Mike had already discussed with compactness, contiguity reflects the idea that districts should represent a geographically consolidated area. However, it is good to keep in mind that some districts are not naturally contiguous, and the courts in those states have determined how contiguity would apply given that particular state's topography and geography. For example, states like Virginia and North Carolina have districts that link coastal islands. And additionally, in practice, roads, rivers, bridges, and tunnels have been used to connect or attach other parts of the district to one another. By state constitution or statute, all states require at least one chamber of the state legislative district or their congressional districts, or sometimes even both congressional and legislative districts, to be contiguous. So let's look at a real world example to illustrate this process a little bit better. You're looking at a state assembly district map for Wisconsin's 47th Assembly District. The district in question that I'm going to talk about today is shaded in orange. And outlined in a black bold box, you can see that parts of the orange Assembly District 47 do not appear to be connected or attached to the rest of the district. They look like small orange islands that are surrounded by a sea of purple, and it resembles the non-contiguous blue district that we saw in the previous slide. However, to foreshadow my next talking point, this district is drawn in such a way as to adhere to a different traditional redistricting principle, mainly the preservation of political subdivisions. The preservation of political subdivisions refers to the general principle that districts are drawn in such a way as to respect existing political boundaries of other local governments, like counties and municipalities, or of other political divisions like wards or precincts, just to name a few. In practice, when drawing electoral districts, these existing political boundaries can be taken into account in order to keep existing constituencies within one district together, rather than splitting that particular constituency across multiple districts. And 44 states include the provision of preserving political subdivisions in one form or another, whether in their constitution or statutes, and whether it applies to their legislative districts or their congressional districts, or again, both. The next example is a simple one, just to demonstrate the principle. It is a map of Wisconsin, of course, since that's where the three of us on this panel are from. If you look on the left-hand side, you will see that county lines were used to county lines are strictly followed when drawing those particular districts. Obviously, it's just an example, and those are not something that would look like real districts in real life. However, the image on the right crosses multiple county boundaries, which could potentially conflict with the preservation of those political boundaries. In practice, the principle of adhering to existing political subdivisions is pretty flexible because most states don't have a detailed set of criteria that describe how counties and municipalities should be split up or preserved. Additionally, some municipalities cross county lines themselves. So if map makers are strictly adhering to county boundaries, that could mean splitting up a particular municipality into two districts. Other redistricting principles may be at play that would account for these splits. For example, if the map maker needed to make two districts equal in terms of population, it would make sense to potentially cross those political boundaries in order to adhere to this federal requirement. So let's again return to our real world example. You have already seen the image on the right. It is once again the 47th Assembly District in Wisconsin, shaded in orange, but this time without a black box. The image on the left displays the town boundaries for the town of Blooming Grove, Wisconsin. And those town boundaries are actually outlined in red. As you can see, most of the town of Blooming Grove is situated to the right or east of Interstate 94. However, there are a couple of pieces of Blooming Grove that are situated to the left or west of Interstate 94. This is because Bloomington Grove includes a few scattered neighborhoods and properties that have been broken into discontinuous sections because of the cities of Monona and Madison. In fact, annexations can commonly create non-contiguous municipal boundaries. So in this case, if we were to back up and look at the legislative district, the orange district that you see on your right, it may look like it might not be contiguous, but you can see that it was actually drawn in such a way as to preserve the unity of the political boundaries of the town of Bloomington Grove. In conclusion, to sort of reiterate what Mike has already previously stated, traditional redistricting principles like contiguity and the unity of political subdivisions is not absolute. Consideration of political subdivisions might mean that a district be non-contiguous because that municipal boundary is itself non-contiguous. It all depends on exactly what the map maker's goals are and if they are prioritizing geographical principles like contiguity, or if they're prioritizing political principles like the preservation of communities of interest when they're drawing a particular district. With that, I'm going to turn it over to my colleague, Joe.
Thank you, Stacy. I'm Joe Cry. I'm a senior legislative attorney for the Wisconsin Legislative Reference Bureau. I've spent most of my 23 years at the Bureau doing taxes, but over the last decade or so, since the last round of redistricting, I've been involved in election law. I want to digress just quickly. Mike mentioned population equality and doing it as nearly as practicable for Congress as opposed to what is possible, and making the distinction between those two terms. And it reminds me of the way that Peter Watson described it. Peter did redistricting for many years, and I believe he worked for the Minnesota State Senate. Somebody can correct me if I have that wrong. But he explained it, and I'm going to paraphrase wildly because I don't remember it exactly, that the difference between the two is that it's possible to get my child to school every day via helicopter. However, that is not practicable. So that's how I always think of the two terms. But anyway, I'll be covering the traditional redistricting principles of preserving the cores of prior districts and avoiding pitting incumbents against each other, otherwise known as incumbent protection. I won't have any fancy graphics for mine, so just bear with me. Although these are considered race-neutral redistricting principles, there are only a handful of states that have these as required criteria for drawing congressional or legislative districts. Other states consider these factors consistent with the legal precedent. According to, and I'm going to do a little plug here for NCSL because why not? The Redistricting 2020 book. According to the Appendix D and E in that guidebook, 11 states are required to preserve the cores of prior districts, and 12 are required to avoid pairing incumbents. That book, by the way, is a good resource for a lot of things that we're touching on today to explain the traditional redistricting principles. And those appendixes are really good to find out which states actually have these kind of requirements. We should note that these principles are not necessarily required by statute or by state constitution, but as I believe both Mike and Jerry noted, it may simply be more or less formally adopted as standards to follow for congressional or legislative redistricting, which is consistent with the court decisions. So first of all is preserving the core. And again, since I don't have a good visual for that, I went with the visual pun. We are not necessarily speaking about the geographic core of the district, but more likely the population centers of any given district. The idea is that preserving the core of the previous district promotes continuity of representation, minimizing changes to the core of the existing districts, also avoids confusion among the electors. They presumably have a much better idea who represents them, and as Jerry mentioned, how to get a hold of them. As a practical matter, starting with the core of the prior district is a pretty efficient and effective way to begin the process of drawing new districts and may promote other traditional redistricting principles, such as maintaining communities of interest or keeping intact political subdivisions. And again, from a map drawer's perspective, starting with that core of the previous district, it's really a good foundation to start drawing lines out and start making the new districts comply with equal population. Finally, as I indicated earlier, the courts have found that preserving the core of prior districts is a legitimate race-neutral principle. Moving on to protecting incumbents. With regard to avoiding pitting incumbents against each other, or otherwise protecting the incumbents, that principle is also considered a race-neutral principle, generally speaking, that also promotes continuity and stability of representation. There has been some debate as to whether protecting incumbents is truly a race-neutral principle, at least to the extent that it may be in conflict with other goals, such as creating majority-minority districts. There is also some academic literature related to that, and as to whether protecting incumbents is a good idea overall. And Jerry may provide some insight on that when he talks about emerging criteria. However, the more widely held take on this is expressed well in a recent redistricting report from the state of Arkansas that states that avoiding pitting incumbents against one another respects the will of the people who chose that incumbent at a recent election. Now, to put kind of a different spin or a different perspective on protecting incumbents, pitting incumbents against one another tends to get some unwanted attention, some negative attention with the courts and with partisans alike. At least that has been the case with the court-drawn maps and the court decisions in the state of Wisconsin. It in many times appears to the court to be at least circumstantial evidence that partisanship has played too big a role in the drafting of the map. And I'm not talking about gerrymandering in particular, but just the way a court kind of evaluates any map before it, or how it goes about producing its own map, probably more importantly. The NCSL Redistricting 2020 Guidebook, which I've already mentioned, cites the Supreme Court decision in Abrams and v. Johnson for this proposition that when considering factors for redistricting, protecting incumbents should be subordinate to other redistricting goals because it's, and I'm quoting the district court, inherently more political. In that case, it's really a culmination of litigation regarding congressional reapportionment and redistricting in Georgia in the 1990s. I don't want to speak too much about that because it's really a case involving majority Black districts. But in that case, the Supreme Court affirmed the map drawn by the district court and examined the process of the district court that it used to draw the new congressional district plan and the new congressional district 11. The state picked up 1 seat after the 1990 census, so they did have to go about reapportionment as well as drawing completely new districts to compensate for the population changes. At that time, Georgia was a covered jurisdiction under Section 5 of the Voting Rights Act, so its plans were subject to pre-clearance by DOJ. The plan ultimately approved by the Department of Justice created 3 majority Black districts, and that was the plan in place for the 1992 general election. But based on challenges after that election, the district court found that race was the predominant factor in the creation of 3 majority Black districts. Put another way, the district court found that creating more than 1 majority Black district would subordinate traditional redistricting principles and allow race to predominate. So to get back to the principles I'm trying to talk about here, when examining the map drawing process by the district court, the Supreme Court noted that the district court first determined where to locate New District 11 and chose an area of significant population growth near Atlanta that would affect the fewest counties. It then turned to consideration of other redistricting principles based on preserving district cores, the 4 longstanding corner districts in the state of Georgia, political subdivisions such as counties and cities, and an urban majority Black district in the Atlanta area. It was in this context that the court indicated it also considered protecting incumbents, but only subordinate to all the other factors, again, because that factor is inherently political. It's also important to note here that the appellants had also challenged the district court's plan as violating the constitutional requirement of 1 person, 1 vote, based on the plan's alleged failure to achieve population equality as nearly as practicable, as Mike had mentioned, our phrase there. The district court had created a plan with an overall population deviation of 0.35% and an average deviation among all the districts of 0.11%. Lower deviations actually than the 1992 plan approved by DOJ. And so as kind of a summary of the importance of these traditional redistricting principles, the district court cited the state policies and conditions that it used and that it relied upon in support of these slight deviations. And the Supreme Court once again reiterated in the case that I cite in the slide here, Karcher v. Daggett, any number of consistently applied legislative policies might justify some variance in population, including, for instance, making districts compact, respecting municipal boundaries, preserving the cores of prior districts, and avoiding contests between incumbents. And on that note, I will take it to Jerry to talk about emerging principles and criteria.
Thank you, Joe. So you just heard about the traditional redistricting principles. There are some new ones. The traditional ones mostly arose starting in the 1960s when redistricting became important because of Supreme Court cases. More recently, some people and academics have questioned some of the traditional redistricting principles. Some 18 states' criteria actually prohibit the entity that draws the districts from using political or election data in drawing plans. Here's the language from the Montana Constitution. So the computer programs that are used now, they start with the population and demographic data from the Census Bureau, but you're able to add additional data, as was noted in an earlier session. The election records actually show the address and party affiliation of every registered voter. So with that, you can aggregate the voters in, the voters in a census block and know the political makeup of everyone in that census block. Additionally, you can get the election results for the last couple of elections. And while you may not be able to break that down to the census block because we don't know how individuals voted, you can at least get the information for the precinct, or in census talk, the voting tally district, or VTD, to get an impression as to how people in that neighborhood voted. And with that information, you might be able to predict how the voters in a district are going to vote. So Iowa has actually prohibited this since 1981, so it's not brand new. But I think the intent is to get politics out of the process as much as possible so you can focus on other criteria. And as you will note from Montana's, some states also prohibit having the information of an incumbent or a candidate's home address in the database. Obviously, this is going to conflict with protecting incumbents and not pairing incumbents against one another. Some states also specify when such data can be used, such as only after the maps have been drawn. Arizona is an example of this. Next slide, Pete. There you go. They allowed it to be used not when you start drawing plans, but after a plan has been done, so that you can verify that you have complied with the Voting Rights Act and other things. You may need to use political and election data to do that. And again, others don't allow it in any stage. I would caution that just because the entity that's drawing the maps can't have this information doesn't mean that others in the state won't have it. I suspect that both political parties in a state will have it and will use it when they compare plans. They may use it to propose amendments to a plan and justify the amendment on some other criteria rather than politics. So I think you're still going to see it used in many states. Another new criteria that states use is prohibiting, favoring, or protecting an incumbent candidate or political party. Here's the language from the Colorado Constitution. Some states also add you can't favor or disfavor. I think if you're favoring someone, you're probably disfavoring the other side. So I don't know that that's necessary always. And again, I think this is to try to avoid the extreme political gerrymandering that we see in some states. So you'll note that in Colorado that this is not actually amongst the usual list of criteria. This is after you've finished drawing the whole plan. We're going to look at the whole plan and see if the whole plan as a whole favors or disfavors anyone. That's unlike Florida. Now in Florida, there are a couple of differences between Colorado. First, you will note that in the priority, Colorado is doing it at the end. It's very high in the priority in Florida. It is in the same priority as protecting racial and language minorities and contiguity. The other thing I want to point out as a difference between Florida and Colorado is that Florida applies this standard not only to the map as a whole, like Colorado does, but to each individual district. And when I get to the last criteria, you'll see how that may play a part. The third criteria is creating as many competitive districts as possible. And 5 states will be using that criteria. The thought is that Competitive districts will require representatives to be more responsive to all of the voters in a district rather than just the voters from the candidate's party. And I think the thought is the practical effect is probably that the representatives from those districts will need to be more moderate from those than those from districts that are solidly in favor of one party. So again, I mentioned the priority of the criteria. Generally, creating as many competitive districts as possible is the last, or at least at the bottom of the list of the priorities, making drawing them really difficult. The population of political parties are often not evenly distributed around the state. Cities tend to be more Democratic strongholds, while rural areas tend to be more Republican. If you're preserving political subdivisions and communities of interest have a higher priority over creating competitive districts, it's going to be difficult to draw those districts. Consequently, I think even in states that have this as a criteria, there are often going to be a number of safe Republican seats, a number of safe Democratic seats, and then hopefully a few competitive districts. But the states believe that it is important to have as many of those competitive districts as possible. Again, if you merge this with the states that prohibit favoring an incumbent candidate or party, especially at the district level, drawing them can be extremely difficult. In Colorado, El Paso County and the city of Colorado Springs, the major city in it, are considered Republican strongholds. It is possible to draw one competitive Senate district in El Paso County and 2 competitive House districts. But obviously, when you do that, you are favoring the Democratic candidates. In Florida, I think those districts you might be able to challenge. In Colorado, again, we'll look at the map as a whole. Has a similar thing been done in a Democratic stronghold, such as Boulder County, where in Boulder County, a competitive district was drawn that you might say would have been favoring a Republican candidate. So this shows how complicated all of these criteria are, and trying to do them makes it very difficult to draw maps and very difficult to draw competitive districts. I think that's the end of our presentation, so we'll probably go to your questions now. And if the others want to join me, the first question is from Mike Fortner. In suburban areas, people often identify more with their school district than city, and definitely more than counties. Have preserving school boundaries been used as a criteria?
Yeah, so and I think that goes to communities of interest. But first, I just have to thank Joe for the practicable smackdown that he gave me. So it was well done. Yeah, and that is one of the, it wasn't listed, I don't think, in the California Constitution, even though that's a pretty extensive list. But school districts is also one of the things that can be taken into account for communities of interest.
And I think
Yeah,
a school district may be considered a political subdivision as well.
Yeah, that's not true in Wisconsin, but I know other states could be different. That isn't, yeah, so.
I think obviously it's easier if the school district boundaries coincide with the other boundaries, because again, in Wisconsin, that's not always the case. So the farther you dig down from county to city and then to school district, the harder it gets to make all these lines. And again, I'm speaking from the perspective of Wisconsin, it's harder to get all these lines to kind of sync up. And in Wisconsin, it's a real problem for the local clerks when it comes to an election when school districts aren't within the other election district boundaries. But.
Okay, I can take the next question. Where can we find a list of the states that do require respecting communities of interest? That's by MN. And another plug for Redistricting 2020, there is an appendix to this that is a chart. It has your states on the left-hand side and a list of all of the criteria, or most of the criteria that we've talked about, including communities of interest. And there's a check, or actually I think there's a letter as to whether it applies to the state legislative districts and the congressional districts. So there you're able to, there's where you can find out where all the states that require respecting communities of interest. Brian Gordon asks, couldn't communities of interest be easily used to pack inner ring Democratic suburbs into Democratic cities, thus adding to the problem of packing cities and cracking suburban counties?
Yeah, and I think that that's political gerrymandering right there, right? So, which the U.S. Supreme Court has said that it won't touch. Although in some states it might be something that you could litigate in state court. Joe, you have anything to add to that?
Yeah, I think, and again, my perspective is having looked at the decades of federal court cases in Wisconsin. At least those courts have been very careful about not mixing the two, so that when they're looking at a community of interest, there was one case probably back from the 90s that the court really needed more information from more information on the ground, basically, that is do we have a cohesive neighborhood? Do they go to the same schools? Do they have some other background that is different from whether or not we should be looking at creating a majority minority district? So they were really careful about trying to keep those two ideas separate if they can. But it's not an easy thing to do, because if you have a compact neighborhood of a racial minority, they have a community of interest related to that for sure. But I think the courts have been pretty careful about trying to separate out that idea of community of interest as being something different.
Here's one for you, Stacy. Would you talk about point contiguity and specifically whether any states explicitly allow it or prohibit it?
So point contiguity exists when the area of the district touches the rest of the area of a district at only one single point. So if you can picture, say, like a checker board, and you have the different colored tiles, two same colored squares that are adjacent on the diagonal of the checkerboard are considered to be point contiguous. As to which states explicitly allow or prohibit it, I don't know that off the top of my head. I don't know if Jerry, Mike, or Joe, you want to weigh in on your point contiguity?
It is prohibited in Wisconsin, right? Or not? Or we don't know. I guess I should probably know that.
I don't believe so.
I think as a general rule, it is prohibited. That point contiguity does not constitute contiguity. I don't know if there's a specific state that allows point contiguity, but I think as a general rule, it is not allowed. Next, ABC asks, how is an incumbent gerrymandering district maps to protect themselves different than criteria of protecting incumbents? Also, why not have the voters decide which of the two they want?
It's a really interesting question. I think I guess the lens I look at it from is protecting incumbents doesn't necessarily at first blush seem like a good idea, but the alternative, pitting two against each other, is kind of the lens I look at that through. And again, based on the way these cases have arisen, what usually is the problem is that to gain an advantage, you're pitting two incumbents against each other who happen to be not not my party affiliation. And so it appears to be looking at an advantage. I don't know if that really answers the question, but I mean, yeah, protecting yourself from being voted out of office, yeah, it's a consideration. It certainly comes up in the gerrymandering cases to give yourself a safe seat. So it's a fine line as far as a legitimate use for protecting the incumbent as opposed to giving yourself what would appear to be an unfair advantage. But I think that also plays into the emerging criteria that Jerry talked about too, where at least there are some states who are not looking at that information.
And Ruben asks, can you explain what criteria takes precedence when multiple criteria are in conflict? Oftentimes, the Constitution or statute will specify which order you're to follow the criteria. In Colorado, our earlier constitutional provision was not explicit about that. And there were court cases that actually, so the courts actually determined what the order of priority was. So again, you're going to need to check either your Constitution and statute, or maybe some of the case law related to the order of the priority that you need to follow.
Yeah, as an example, the California Constitution explicitly subordinates compactness to communities of interest and certain other principles like that. So.
And here's one that I don't know the answer to, maybe someone does, but what happens if some of these criteria are not implementable using a redistricting algorithm? And I think that's a new mathematical process for drawing plans using a mathematical algorithm rather than looking at some traditional criteria. And while I haven't used algorithms in the past, I think you would probably run the algorithms, and if you had maps that violated some criteria that you couldn't put into the algorithm, you just have to look at all of those maps on an individual basis to take a look at it.
Yeah, it may be that you end up judging the result after the fact. So you run your algorithm, and then you compare it to what the principles are you're trying to accomplish. It might be the way to approach that.
And the last question that I see is from John on the I think it's the New York Senate Redistricting Commissioner. Where does nesting and coterminally fall in the criteria hierarchy? And I'm not familiar with the.
Yeah, that's a stump the panel type question, isn't it?
I am not familiar enough with the New York Constitution, and I think it's been changed, at least with the new commission. So I'm going to have to punt on that one. I think you're going to have to ask someone in the New York Senate who we may have around later today if you want to ask that question later today. And I think we're about out of time. If anyone has any last minute questions, feel free to ask. Otherwise, I know I will at least be around although I don't consider myself an expert, I have been invited to be at the ask the experts after this, so I'll be around. And with that, thank you for your attention. And I think the next session starts in about 10 minutes. So stick around, and if you have any questions of any of the panelists from any of the sessions today, we should be around to answer any of those questions that you may have. And again, thank you for your attention.